Hello, everyone. This is Tom Fox, back again with Mike DeBernardis, partner at Hughes Hubbard, for another episode of the Corruption Files. Today, we're going to take up a case that perhaps is not as well remembered as it should be, because it turns out it was quite seminal in a lot of later developments, and that's the Parker drilling case. So, Mike, first of all, welcome back.
Thanks, Tom. Happy to be back and continuing the series.
So, Mike, this case always interested me. Number one, it's a company in Houston, fairly well known in the energy space, but it had C-suite involvement in the bribery schemes. The facts and circumstances I was reminded of when I went back to do our research for this podcast are still instructive today. And perhaps most significantly, this was the first case where we saw clear credit given for the remediation during the pendency of the investigation. And we're going to explore all of those. This case was released the enforcement action was released in April of 2013. It was a relatively small amount of fine for that point in time, a DOJ fine of $11 million plus an SEC fine of just over $4 million. But the conduct went back literally to the mid-90s going forward. And the conduct was around, Parker Drilling was an oil rig drilling company, and they had a lot of offshore rigs. And in the early part of this century, oil was going up, so drilling was pretty heavy. And Parker had rigs going in and out of the country of Nigeria. Nigeria had a tax scheme that if you had a permanent rig on site, it was a pretty hefty tax, but if you had a temporary rig, which was 6 months or under, largely offshore, you could get a temporary import permit, and your tax bill was much, much less. Parker bought a company called Mallard, which had rigs operating in and around Nigeria, and that's really where this story starts, because it appears that this underlying purchase, there was no due diligence from the compliance perspective. There was no look at the agents. There was no look at sort of the tax regime these rigs were under. And that was in 96, and Parker continued to use the same companies to get rigs into this temporary import permit tax regime. That happened until about 99 or the early aughts of this century. And at that point, the legacy agent from Mallard said that they could no longer provide that service. So Parker switched over to Panalpina, whom we have talked about previously. And Panalpina was able to get this temporary service, but it was pretty clear from the facts and the criminal information that they were fudging these permits, providing full information, because these rigs were staying in Nigeria longer than 6 months. So under the correct regime, you had to leave every 6 months and come back, or you had to get an extension. Well, after a couple of years, it turned out that Panalpina could not get the temporary permits. So Parker solicited and received advice from an unnamed outside U.S. law firm, identified that way in the information, and that law firm recommended a new Nigerian agent. That recommended agent had no experience in the energy space, had no experience in the tax world, was known as a, quote, fixer, end quote. And that agent was able to, with the help of fraudulent filings from Parker, continue the tax abatements through the tax import regime, or the temporary tax import permits that Parker was able to obtain. That happened for a couple of years. And then the government of Nigeria decided to take a look at the tax regime, and they instituted a tax import panel in 2002. That tax import panel found that Panalpina had violated the taxing regimes and was going to proposed an assessed fine of $3.8 million. Well, that's when the fixer came in, and the fixer started fixing, and the fixer fixed by bribing corrupt Nigerian officials, both in the tax panel, the tax department, or the tax function in the country, and all the way up to the president. And they did this through funding directly from Parker. Now, the money came from Parker, I shouldn't say directly, but it was funneled through the law firm. In about '03 or '04, interestingly, Parker Drilling Finance Department picked up these funds, which were being sent to the law firm without an invoice and without a contract and without a description of services, and said, under Sarbanes-Oxley, we can't do this anymore. We need a description of services and we need an invoice. So the corrupt law firm began providing invoices and services, and with the simple description, for legal services rendered. Now, these were not $5,000 or $10,000 invoices. They were as high as $350,000. They were multiple $100,000 invoices, but the invoice payments had the desired effect, and that was that with the bribes paid, they were able to reduce the overall tax assessment from $3.8 million to $750,000. So that's what led to the enforcement action. There's a lot more to unpack, but I wanted to stop there and maybe get your take on this bribery scheme and see if you think it's still relevant really for compliance practitioners to study today.
And I think to answer that second question first, it is certainly still relevant. I think we'll probably unpack some of that as we go along here. One of the things that stood out to me rereading the documents, the charging documents in this case, I had remembered this as tied to the Panalpina settlement and all of the Tidewater and Transocean and Shell Nigeria settlements that went along with it. And part of the reason I remembered it that way is that it still says that it's related to Panalpina, that this investigation came out of the Panalpina investigation. But it's a little bit different, right? Because the Panalpina related cases really were, as you described, Panalpina maybe bribing customs officials to avoid this import tax or to accept these fudged documents. The focus of the information here is really on the efforts, not on Panalpina, although that sort of created the mess, but the efforts of this referred to as the Nigerian agent, the fixer, as you said, to reduce the fine that this special panel that was set up was going to levy on Parker Drilling. And I think you mentioned it was $3.8 million is what they were going to levy after the Nigerian agent did his work. They reduced the fine to $750,000. So it was basically a $3 million savings for Parker Drilling. So that stood out to me. I just I misremembered that, and it does create a slightly different situation. Another situation, I think, where we're talking about not obtaining or retaining business, but of obtaining an improper advantage in the language of the FCPA. The other thing that given my position, that really stood out to me was the involvement of this outside law firm in the scheme, really here. And as you mentioned, all the payments were routed through the law firm. The law firm introduced the agent to Parker Drilling as a potential solution. The law firm provided his bio, which, as you mentioned, didn't reference any particularly relevant skills for the job. And Parker Drilling, of course, didn't do any additional due diligence. It's just not a fact pattern that you see very often. And it's another kind of interesting fact pattern to consider for compliance professionals as you're looking at risk areas and looking at areas that you would typically consider to be very low risk or no risk. Just a reminder that maybe there is no such thing as low risk or no risk. And then, I think the final thing that stood out to me is, when you look at this, even the criminal information, which is for a substantive violation of the anti-bribery provisions of the FCPA, it reads more like a books and records case in a lot of ways, right? The focus seems to be on the fact that they're paying these amounts of money. They didn't know what was happening with the money necessarily, although it's sort of alluded to that there was entertainment involved, but the information is not specific about what actually happened with the money. But what they do focus on is that you have all these sort of fake, very very obviously fake invoices or invoices that don't accurately describe where the money's going. Very poor internal controls at the time, and so it does read more like a books and records case. I think, if I remember correctly, the SEC did charge them with a books and records violation. But it's interesting to me that they landed on a substantive anti-bribery charge when it certainly reads more like a books and records charge.
And that probably relates to the next fact, which I really should have mentioned before in my recitation, which was we had CEO and general counsel involvement direct C-suite involvement in this. And at that time, I thought it took this case really to a different realm, and that may have been one of the reasons the DOJ was so excised in this matter. But Mike, even though this started in 96, I really felt like the bribery scheme still had relevance for today's compliance professional, because clearly M&A was a part of this, or lack of M&A due diligence. And as you pointed out, was the lack of substantive due diligence on the agent, the final agent they used. I was very intrigued that internally Parker Drilling's finance department picked this up in the context of SOX certifications. So it shows, I think, that we've all speculated as to what led to the explosion of FCPA enforcement in sort of 04 to 08. And some people think it's a requirement under SOX that finance could go and say, we now have to demonstrate documented evidence to back up our payments. And that was one of the reasons. There may be others, such as national security or others, but this is really a case is a great example of showing how SOX and SOX certification drove compliance, and that's certainly still with us today. And for me, document was my mantra then, and it still is. And I really saw that in this case as well, tied together with the point you brought up, which is it's not simply a quid pro quo of a bribe to get a contract. It's to gain a business advantage. And here the business advantage was exactly that, a tax ruling or a reduction of a fine and penalty. It was so significant that, like I said, it went all the way up to the CEO and general counsel. So we had, I thought, some lessons that we can still draw upon, and compliance officers can even use these lessons in board training or other training. It shows the power of internal controls when you either create them or first put them in place and use them effectively. And I'm probably going to rue that I said this, but perhaps there is something to certifications. And if you put sub-certifications in place that roll up the evidence of an act that was in compliance with your internal controls, and then you certify the internal controls were effective, perhaps it certainly was one of the factors in this case. And perhaps I've had other internal audit specialists advocate to me that SOX was very important for their profession, and maybe CCO certifications will find out the same thing. Although, like I said, I already feel bad that I said that. But we saw it in this case. So I thought that was really interesting as well. But I'd like to turn to the remediation, the fine and penalty, and in context talk about the remediation. And I'm going to go back to the DPA itself. Early on, when I started in my compliance career, I was fascinated by the fine calculations because I thought this was, I don't want to say opaque, but certainly difficult to figure out precisely how they got to a specific amount. And there's a formula under the U.S. sentencing guidelines with an offense level, base offense, value of benefits received, culpability scores, number of people in an organization. And then there's a discount, and that discount is given for the following. Quote, the organization fully cooperated in the investigation and clearly demonstrated recognition and affirmative acceptance of responsibility for its criminal conduct, end quote. And you can receive up to 5 discount points from that. Well, here Parker Drilling received 2, which tells me they didn't meet all of the requirements under this section. We don't know what they didn't meet. I'm going to explain later why I think remediation was given credit for, but there was no self-disclosure in this case. It's not clear whether there was extensive cooperation or at what point there was extensive cooperation and where somebody finally got the message. But the DOJ was not satisfied with the conduct of Parker Drilling as reflected in the sentencing guideline formula. But the sentencing guidelines then give you a multiplier, and that multiplier gives you a range of fine and penalty from a low to a high. Well, here, Parker Drilling, with no self-disclosure, with unclear what the cooperation was, received a 20% discount. And I will have to tell you that many of us in 2013 scratched our heads a long time because we could not figure out how Parker Drilling got 20% off. It was actually there in black and white, but we'd never seen it before, so we didn't know exactly what it meant. And the DOJ and other commentators later explained that it was the remediation. And it was the extensive remediation. And at that point, we typically didn't remediate during the pendency of an investigation. We waited till the end. Well, Parker Drilling hired a guy, and I'm going to name him because I've heard government officials name him. His name is Dan Chapman. And I have heard them say at conferences, he came in and put together a best-in-class compliance program during the investigation, which literally blew the socks off of the investigators to the point where they credited significantly that remediation in the form of a discount. And about 6 months after this, the then head of the FCPA unit spoke at the ACI National FCPA Conference, and he talked about this discount. And I didn't attend the conference, so I called him up and asked him, where did this come from? And he kind of shyly said, I guess we didn't explain that very well in the DPA. But he walked me through their decision-making process, and it made a logical sense, and it made intellectual sense. And for the first time, I understood there was real credit to be received. And I introduced that, or I use that as a long introduction to asking you how that, in your mind, may have formed the basis of the FCPA pilot program, the FCPA corporate enforcement program, and really all the way up to the Monaco memo today.
Yeah, it's really interesting. I was actually going back, as I was doing the research for this podcast, went back and was looking at some prior DPAs and plea agreements. And you see, sometimes it's even less clear than this, right? They would put a number and say, here's the guideline range. The company agrees to X, which would be lower than the guideline range. No explanation at all as to why that number would be lower, and they wouldn't even put a percentage on it. Just here's a lower number that we're going to agree to. I think your point specifically on your discussion with the head of the FCPA unit, and we should have described that better maybe in the documents. To me, that's the direction that we went with the pilot program, where we said, okay, if we're going to do this, if we are going to affirmatively give credit beyond the credit that's built in already to the sentencing guideline calculation to companies who do certain things, let's spell that out, one. And two, let's try to put in place a system that makes it somewhat consistent. It's never going to be fully consistent because the facts and circumstances are always going to be different. The purpose of the sentencing guidelines themselves is to try to make things a little more consistent. It doesn't mean they work perfectly, but it tries to sort of put everything objectively in the sort of same frame of reference. And I think that's what we had with the pilot program, where, all right, if you do X, Y, and Z, here's what you can expect, right? Or if you fail to voluntarily disclose, here's the maximum credit you can get. That was sort of the first shot at it. Let's try to lay out these factors to allow companies to understand what they might be getting themselves into, what we expect, and encourage them to do certain things, right? We want to encourage them to self-disclose. Even if they don't self-disclose, we want to encourage them to cooperate, to remediate, do all those things. Then when once the pilot program showed some success, in the next iteration, when they moved it to a more permanent policy with the corporate enforcement program, they tried to be even more specific, because I think some of the feedback they got was, hey, this is helpful, but it's not, you're not fully there. We still have a lot of questions about what we can expect, what kind of credit we're going to get. And so that tried to that iteration had a little bit more detail about what to expect and what not to expect. You're not going to get a declination if X, Y, and Z, or you should expect, assuming that you voluntarily self-disclose and do these other things, that you will actually get a declination. And then, I think with policy revisions, as we've seen going forward, up to and including the Monaco memo, it's really been to sort of tighten this up and offer as conclusive guidance as we possibly can, recognizing that no two situations are going to be the same. So we can't give any guarantees as to what's going to happen. But I felt like there was even more of that in the Monaco memo, especially when there was talk about self-disclosure and what to expect if you self-disclose and not having a monitor and all those things. So this was, I think they struck something here with Parker Drilling, saying, hey, not only is this good to reward companies, but if we're going to do that, let's publicize it so companies know and are doing these right things that we would like them to do so that they can get credit. And then let's try to make it consistent so that the credit is consistent. So it does fit together. And I have to do a little bit more research to point to exactly this case, but it's certainly right around this time when it all starts and kind of moves forward from there.
So the other thing, Mike, one of the themes I think we've seen throughout the history of, or at least the last 15 years of FCPA enforcement, is not so much an ebb and flow, but a dialogue between the department, companies, practitioners such as ourselves, certainly around monitors, a dialogue around fines and penalties. We had Supreme Court rulings and a lot in the mix. And the more I thought about it, I really saw this as a part of that dialogue. And that dialogue being people like you and I saying, if we're going to put forth the effort, we should get some credit for it, or at least don't penalize us more if we go ahead and do it. And the DOJ actually taking that information, whether they develop that internally or listen to people like us in enforcement actions or people like you when you're sitting across the table from them, that was a change. And so we see evolution here. And I really point to this as this and Ralph Lauren, which I hope we can explore on another podcast, as the first two where it really showed up in the charging documents, or in Ralph Lauren, it was an SEC complaint. So I think this is a long forgotten but a significant case going forward. The open question I think both of us have is around the individuals and why there was no individual prosecution. We've never really heard one way or the other. The company, to the point, the company fully funded the defense of the two individuals and never tried to cut them off or anything. But that's really an open question. But we did have C-suite involvement. And I guess the final message I try to use in this case is the facts were as bad as they get, but if you engage in the proper conduct, at least as the department sees it, you can get significant credit for it. And I thought that was a pretty significant message that we both still carry today.
Yeah, for sure. And I think, it's one thing, you touched upon this already, but it's one thing to take the steps to implement a program and to make the remediation in terms of we're going to change our internal controls and that kind of thing. I think one of the aspects that's sometimes missed is having the right people in place. And you mentioned already that they hired Ken Chapman as the new CCO. And from what I understand, he brought in a team. It wasn't just him. He brought in some really sharp, very professional compliance officers into this organization. That's impactful if you think about it. As this process is playing along, you're in discussions with the Department of Justice and the SEC. You are, every time you're meeting with them, talking about these new, really highly qualified, very sharp compliance professionals that you're putting in your organization. That's impactful, and especially coming from where it seems Parker Drilling was. Reading between the lines a little bit in the information, it seems like they had embedded their compliance responsibilities maybe with the CFO, or one of the executives that was at fault here had some compliance responsibilities. And so to do a complete 180 on that and say, we're going to bring in a real compliance professional here, someone with a track record, he's going to build up the team he wants to get the job done, is really impactful beyond just the sort of program changes that come with it.
So, as I said, I really found this case, first of all, I thought it was very instructive for just some basic points: M&A due diligence, agent due diligence, documentation of agent invoices and services, wire transfers. Some have a second set of eyes on wire transfers over certain amounts. And always remember, it's not simply the quid pro quo of bribe for a contract. It's really any business advantage. And here, tax payment reduction or tax liability reduction was seen as a benefit. So I think that's things that we still talk about today. We've both extensively talk about remediation. So maybe a final thought or two on Parker Drilling?
Yeah, I think if and I use this one a lot, but just sort of doing, a risk analysis of your various operations. Obviously, as I sort of alluded to, typically for a U.S. company, their interactions with U.S. counsel is not considered to be one of the higher risk FCPA areas. But when you're thinking about the purpose of that engagement, and if it's for fighting potential legal ruling or tax ruling in a foreign country, particularly one as Nigeria that has a history of corruption, you got to rethink the risk analysis in all of it. So it's one of the hardest things, I think, for companies, for compliance professionals, is to juggle all these various risks. You're a company like Parker Drilling, you got risks kind of in various different areas. But it's really focusing in on not necessarily just where that individual or where that company that we're dealing with is, but what they're doing kind of on each step of the way.
Well, Mike, unfortunately, we're near the end of our time for this episode, but I look forward to what we come up with next time.
Yeah, thanks a lot, Tom. It was fun.